Turn to the second case on this morning's docket. That is case number 117368 in the interest of AAF, MAF, FAF, BC, and JS minor children.
May it please the court, Andy Venduska appears on behalf of the natural mother, DS. I would respectfully request 5 minutes rebuttal time.
5 minutes is granted.
Thank you, Your Honor. As a brief overview of this case, this matter is a child in need of care case that was transferred to Geary County from the state of California based upon pending proceedings that had already begun over there and had several years of court documents that had accumulated. The parents had moved to Geary County. The California court had become aware of that move. The children remained in the state of California. Based upon the parents moving, California has contacted Judge Segura in Geary County to request transfer. That transfer did in fact occur. However, there is no record as to what the parties could review to determine what had occurred. So
isn't that where this whole case falls off the rails? And isn't that because you're in the wrong court? If you're going to challenge the California decision, don't you have to be in California to do it?
I would agree with you. As was presented.
So how do you bring this appeal? By your client waiving what rulings were made in California, not appealing that decision directly there, hasn't she waived any objection she has to the merits of that ruling? And as I understand it, you're only attacking the merits.
I would disagree. As the UCCJEA states, that's one of the limiting factors we have regarding a Kansas court assuming jurisdiction of a case.
But Judge Segura had an order in her hand. California transferred jurisdiction to Kansas. They'd had a conversation. She gave permission for that to happen. That provision, the inconvenient forum provision of the UC Uniform Act, had been followed for all intents and purposes on its face. So why isn't that order given in Kansas, whatever doctrine you want to apply, full faith and credit, comity, collateral estoppel, whatever, why isn't that a binding order on the Kansas court that jurisdiction has been transferred, and how can it be collaterally attacked?
Because the natural mother in this case was unable to actually attack it in Kansas when it was initially transferred, because there was no record that was created in order for her to say, well, this is the reason that California is requesting the transfer.
My point is the reason that record isn't in Kansas is that it is in California, and that's where the attack should occur. That's where the mother needed to be to attack the validity of the California order.
Then how is it, and I guess my question that then flows from that is, okay, so if she's not in California but she's in Kansas, the children remain in California, California is requesting that the case be transferred to Kansas. Really, it then falls on her lawyers to be in contact with her, even if she is in the state of Kansas, to determine whether, in fact, she wants the case transferred. There's no record that supports the reason for the transfer. There's no record saying that she did not want to, in fact, object to the transfer, which, certainly there is an effective assistance of counsel claim she may have with her California lawyer, but we in Kansas have no ability to attack this court subject matter jurisdiction because we don't have a record that would allow us to understand why it in fact was being. We don't have an email between the courts or anything that would allow the Kansas attorneys to say this is not the proper forum for this. This case should remain in California.
Let me ask it a different way. Between California and Kansas, which jurisdiction makes the initial decision to transfer and makes the findings necessary under the UCCJEA or whatever
I think it's really a two-part analysis. It depends on really where the children are located at. Because if it's an emergency jurisdiction issue in Kansas, where Kansas is either trying to assume jurisdiction or at least has an emergency that has arisen, should these children be returned to California? So
Are you alleging that this was an emergency situation?
No, I am not.
Okay, in this case, wasn't it California that had the authority and responsibility to make the findings necessary as to where the forum would be?
Yes, but both courts are required, both courts, California court as well as Kansas courts, are required to make a sufficient record for it to be reviewed by the counsel of the parties, by the courts and the appellate system if this gets appealed. So without a record, we have no ability to understand why it was California requesting the transfer, because the children remained in California.
So you're saying the Kansas court violated its obligation to have a sufficient record by which your client could challenge the transfer?
Yes.
Is that your argument?
That is my argument.
And the authority for that is?
In the UCCJEA itself. It says that the statute requires that a sufficient record shall be maintained in order for it to be reviewed, whether that is an auditory for the courts that use the speaker system and not actually have a court reporter, or actually have a court reporter in to take the record. At the very least, have a sufficient journal entry that may suffice. Again, the way the technology has, an email itself would have at least given us the ability to see what was the thought process of the California court, as well as Judge Segura here in Geary County. That's the reason why she was accepting the case being transferred to Kansas. We don't have that, so we have no ability to say it should not have been transferred based upon that reasoning. Now then that comes to the next question. How do we necessarily say that why wasn't it contested over in California when that should have been where it was contested? Because California is not here. This is where her rights were in fact terminated, was in Kansas. So what we're trying to seek relief from is the termination, because Kansas didn't have subject matter jurisdiction, and we couldn't contest that because there was no record to show why it was in fact here in the first place. So that's, I think that.
So is that a procedural due process issue that you're raising? What's the theory of your attack on subject matter jurisdiction?
It is procedural. Because in order for Kansas to assume jurisdiction of this type of case, where children are presently residing outside of the state of Kansas, they have to go through the proper process of accepting that case, and in order to do so, they have to follow the statute. And I'd say they have to follow it to a T.
Usually courts do not look behind the decision of another court. What is your theory for giving the permission to do it here?
Because the statute requires them to state the reasons that they are in fact accepting transfer.
But where is the authority that the receiving court can question the procedure that was done in the other state? Why is Judge Segura not entitled to just give good faith to that order? She received it, she had the phone conversation, and so acting, good faith, giving credit to that decision that was made in California.
Much like the parties have to build a sufficient record in order for future courts to review it, to understand what has occurred, I think the same thing has to happen for the parties to understand why Judge Segura made that decision as to why she accepted.
In essence, you would say that a trial court receiving a child custody case acts as an appellate court over the transferring jurisdiction court, so that trial court in Kansas sits and reviews the record of the transferring court, the California court, and says, okay, yes, you did everything you're supposed to do, so I approve it.
Yes.
So they in essence can say, no, I'm reversing your decision?
I think what the Kansas court can say is, if I'm going to accept your transfer of this case, I have to build a sufficient record for the parties to understand what my reasoning for that was. And if that is from the sending state to say, we believe that Kansas is a more convenient forum based upon the parents being available within the state, then that has to be set out in a record. I don't think it's Kansas necessarily reviewing it, although Judge Segura has the discretion to deny transfer, much the same as California has the ability to deny transfer if Kansas was requesting the transfer. So the sending state and the receiving state both have the ability to deny it. But if they are both on the same page and they want that to be the transfer to occur, there has to be a proper record made in order for us to understand what the purpose of the transfer was. Specific to this case, the children remained within the state of California at the time of transfer. It doesn't make it a more convenient forum for Kansas to accept transfer.
Now you're arguing the merits, but I
Sure.
want to review. It seems like to me, well, first of all, what's your authority for the idea that the Kansas court had an obligation to make a record of underlying the California judge's decision?
The UCCJEA sets forth the procedure
What
that
specific?
there is a specific statute and,
Okay, I'll give you a chance to look that up later.
okay.
But isn't Judge Segura's agreement to accept transfer? That's the point at which she can either deny or agree to take it, right?
I would agree.
Okay, it's not a matter of denying it later. Once the
Right.
transfer orders, it's her participation in the fact-finding process of the California court, is it not?
It is.
Her agreement or refusal is just a fact considered by the California judge.
And the statute requires her to make a record of the proceedings in which she had with that other California court judge to determine why the transfer itself was being
And that's the cite you're
made.
going to get from me. That's the cite you're going to get from me that says she has the responsibility to make the record as opposed to the California court making the decision.
I would say that Kansas statute doesn't have the ability to order a California court to make a record regarding its reason for sending the state. However, the statute here in Kansas does have the ability to order a Kansas judge to make a record regarding why it is accepting transfer. So the best I can give you is that because the statute requires Judge Segura to make a record as to the proceedings that occurred regarding the transfer, she had to make that record.
What is
Go ahead.
What is the minimum, in your legal view, that Judge Segura had to do to satisfy you?
She had to make a record, whether it was a recording of the conversation she had with the judge over in California, whether that's done by a court reporter, whether that's done by simply turning on the system that may be in the courtroom, but that it can in fact be transcribed. The parties can review it, even if it's just hearing it versus even reading it. There has to be some record to show this is the thought process that went through it, so there has to be something we can tangibly review as to the purpose of the transfer and the reasoning behind it.
And as I understand, just in the Judge Segura's response was, I depended on the California court to do that. And so what steps have you taken to determine what record there is in California?
There is no record in California. During the trial court process, it was requested that there be either a transcript sent of those proceedings or at least a document or journal entry that sets forth the basis for the transfer. It does not exist.
How do we know that?
Because it
What
wasn't,
record have you made for your appeal today to verify to us that there is no California record?
it's my understanding at the district court level that was in fact requested and those records did not exist. Now, whether I filed a supplemental request or addition to the record, that has not been accomplished because those do not exist for me to have supplemented the record with it.
And whose burden is it here to establish that, do you think? Is it yours or the state's?
I believe it's the state's burden to prove that this court or that Geary County had subject matter jurisdiction. So if
So it's in your view, it's the party attacking the jurisdiction does not have the burden?
no, I believe that the party stating that the court had subject matter jurisdiction has the obligation to prove it, in fact, did.
And you have authority for that.
The cases that have led up to that have been all, I should say, Court of Appeals cases. Honor AA is kind of our leading case for how practitioners have dealt with that specific issue. And I think it does in fact cite to in the estate of Hyman, which was affirmed by this court, which states that the party who has stated that the court has subject matter jurisdiction has the responsibility to in fact show that the court in the district court level had subject matter jurisdiction of the issue. There are no immediate questions. I see that I'm out of time.
I see no further questions. Thank you, Counsel.
Thank you.
May it please the court, the appellee appears by Jason Oxford. I'm an assistant county attorney with Geary County. I represent Geary County in this matter, and I'm prepared for argument. Listening to the statements of the justices and Mr. Vendeska's responses, I would agree, Justice Lukert, that full faith and credit was given. If you read the record, Kansas court, upon hearing the objections, noted on the record at the termination hearing that the court was unaware of anything that would indicate jurisdiction was erroneously with the Kansas court, that the court took jurisdiction under the UCCJEA and the ICPC, and that the court followed the guidelines in conversation with the California court as it relates to the record and what record was made. Without a record affirmatively demonstrating error, an appellate court presumes the action of the lower court was proper. As it relates
Do you
to,
think all the Kansas record has to show is Judge Segura making a comment on the record that I have had this conversation, I accepted, and that's sufficient from the Kansas side?
I think it is sufficient from the Kansas side, yes. There was an order that was submitted by the court in this matter as it relates to citations of federal jurisdiction, and how that relates to and how the process and jurisdiction going from state court to federal court may be authoritative in this matter. I guess that's the way I was reading the order. I do think that the burden is on the party who is invoking jurisdiction. In this case, it would be the mother saying that jurisdiction, subject matter jurisdiction, is more appropriately in California. And
what would have been the mechanism to allow counsel here to understand what was going on in California? Seems to me that just having a conversation from one jurisdiction to another that says, yes, we're going to agree jurisdiction should be here, doesn't lend itself to what was happened in California. How is that supposed to happen?
I think that
or is it even relevant? I mean, first, how's it supposed to happen?
I suppose that if a party is wanting to assert that something went wrong in California, it would be their burden to make findings into that, to request a record, to maybe even talk to their client about the matter before getting to the termination hearing. This is a case that was transferred in June of 2015. It was set for termination hearing several months later. Trying to see here. But there was ample time for that type of investigation to have occurred. It didn't seem to. I think that the mother also presumed that subject matter jurisdiction lied with the Kansas court because there was no question about it. There was nothing, no objection, no fact finding, no inquiry up until, and really there never has been. Even at the termination hearing, there's simply a vague objection. There's no citation offered. There's no discussion that is given. There's no research or inquiry other than we object because we don't think that subject matter jurisdiction is appropriately before this court. again,
But subject matter jurisdiction can be challenged at any time.
it can, yes, I understand, and as I was reading the Court of Appeals opinion on this, I understand that. I also understand that as it relates to state courts are courts of general jurisdiction, and but the UCCJEA limits Kansas courts, as it does, I assume, all other courts, all other state courts that are under that act. The federal system and the way they handle that, if you are the moving party, if you're the party who is asking to invoke jurisdiction in another state or in another jurisdiction period, then it's your burden. And there's under the federal guidelines, there's a presumption against jurisdiction lying with the federal court, going from the state court to the federal court. I think that the burden likewise should be on the moving party, the party who is invoking jurisdiction in the California court. That would be the mother. I think that the mother's in the best position to do so. The mother is the individual whose attorney was present, who asked for the transfer from California to Kansas. If the court looks at the forum requirements, or I guess the most appropriate forum requirements, the mother had been in Kansas for about 8 months, from mid-October of 2014, when the transfer occurred in June of 2015. The mother had Section 8 voucher for housing at the time of the transfer, was receiving therapy in April of 2015. After the court in California entered the transfer order, there were no more custody orders issued. There's just evidence that suggests that that's what everybody had in mind. And again, without affirmatively demonstrating error, an appellate court presumes the action of the lower court was proper.
What's your take on this argument that the district court failed in its duty to maintain an adequate or make an adequate record?
Again, I think that Judge Seguero, in her conversation with the California court, and it's not, there's no record whatsoever, but there is as I understand, a one paragraph order, 2-page minute sheet from the California court that indicates that the parties, present parties, the state, mom's attorney, the mother's attorney, court personnel, that there was a judge there, a court reporter, the issues that were considered, and the disposition of those issues, along with the conversation with Judge Seguero between the two judges.
What does that say in other words, what is said in the record about that conversation between the courts?
Judge, if I could have just a second.
If you're unable to find it, that's fine.
I'm not able to find it at the moment, Judge. Just that Judge Seguero and I wrote down verbatim what Ms. Brown's brief to the court, supplemental brief to the court stated, which is that Judge Seguero advised on the record that she was unaware of anything that would indicate jurisdiction was erroneously with the Kansas court, that the court took jurisdiction under the UCCJEA, and the court followed the guidelines in the conversation.
It was record 10, page 17. That's where that is, and that's exactly what it says, basically.
So, yes.
I'll just follow up. Earlier there was some discussion about where in the statute that requirement is, and your opposing counsel may cite to other parts, but I at least see 37,110 requiring a record to be made of any communication between courts. And is it your position that what that means is just a record that there was a communication, and it doesn't require any sort of substantive recitation of the substance of that communication?
That would be the state's position, yes.
And what would that accomplish? Other than the judge here saying, yes, I talked with the judge in California, period.
I think it just indicates that Judge Segura understood what was required under UCCJEA, had a conversation with the court about what happened in California, and based upon that made a finding that it was appropriate for to accept transfer. And
Well, the judge said that the court followed the guidelines. How does opposing counsel know that's what the judge did?
right, again, this is an inquiry. This was an objection made at the termination hearing. It was actually not even initiated by the mother. As I understand, the father made the objection. The mother then joined, gave no basis for why it was objecting other than that it didn't feel that jurisdiction was appropriate. There had been months leading up to that time. If the mother did not feel like jurisdiction was appropriate, the mother could have inquired, could have made a record, could have investigated that matter, but that did not occur.
And as I understand it, the California court's order also indicated that the consultation had been made.
I can't say that for sure. If that's in Ms. Brown's brief, then I would take that as word. So yes, and I know there was a record made because there was apparently a court reporter there. It was indicated the court reporter was present at that proceeding when the mother's attorney was present, state was present, and the court when the transfer decision was made, apparently, or at least preliminarily before maybe having a discussion with Judge Segura when that order was entered.
And do you understand that the purpose of that conversation was simply for Judge Segura to indicate whether she would accept jurisdiction?
Yes, that is my understanding. Yes, but again, not trying to harp on this matter, but again, this is a situation where the mother never at any point in time before, and never really since, has ever challenged the appropriateness, content, or authenticity of the conversation between the Kansas court and the California court, never asked the court to explain the details of the court's conversation, never requested a transcript of the hearing in California when venue was transferred.
Do you have any further presentation?
I don't have any further statements at this time. If the court has any questions, I'll certainly entertain them.
Do we have any more questions?
Quick question.
Yeah.
If this court were to determine that the lower court failed in its duty to create a record of a communication with another court, do you have any position on what the proper remedy under the statute would be?
Well, I think that the Court of Appeals, in a roundabout way, stated kind of an overwhelming policy decision at the end of this, because the Court of Appeals essentially said that there was no subject matter jurisdiction in Kansas for this case to continue on, but that it would make no sense to send it back to California at this point in time because no reasonable California court would make the decision to keep it there and not send it back to Kansas. And so that would be the state's hope, I guess, that if there was a finding adverse to the state on that issue, then that the Supreme Court would follow that initiative, I guess, by the Court of Appeals.
Sometimes court proceedings are not necessarily efficient. Is there any justification for not doing this correctly? I mean, if we remand, doesn't the California court have to go back and unfortunately, I'm not real sure we have a grasp on what the contention is the defects were in California.
Right.
But whatever those were, make sure that the procedures are properly followed to enter a correct order. Is there any way really to avoid that?
I think that the court can I think this court can follow with the Court of Appeals decision on its policy basis, I guess, for not sending it back to California. You've got children involved, some of them up for adoption, some of them that.
Do you have any authority that harmless error applies to subject matter jurisdiction? And isn't that essentially what the Court of Appeals said was, there wasn't subject matter jurisdiction, but we deem it harmless because that's what courts probably would have said.
I don't have any authority on that, Judge.
To the contrary, we've said that subject matter jurisdiction can be raised any time because it results in action that's null and void. And we do have some action here by the Kansas court that's pretty significant, a termination of parental rights. Why isn't that void if the court didn't have jurisdiction over the subject matter of the children when it entered that termination order?
Well, the state's position is that the Kansas court did have subject matter jurisdiction, and it's not null and void.
I know that's your position, but didn't the Court of Appeals say basically there wasn't?
And I think they were wrong on that issue.
Any further questions? Thank you, counsel.
Just to follow up on some of the points, and really it's kind of a reiteration of what we've talked about, is that just because Kansas says it has jurisdiction doesn't mean it has jurisdiction. There has to be a sufficient showing of the reasons for the jurisdiction. That sufficient reasons in this case, there's no record that does in fact show it, so we have nothing that we can rely on.
I want to parse that just a little bit so I'm really clear that I understand what you're saying. When you made that statement, are you talking about California?
I'm talking about Kansas's record.
And what would a trial judge in Kansas, what would their record, I understand you're talking about a recording. I'm past kind of the practical about how that's made, but what is it that you think that record must show?
Kansas has to show the analysis it went through as to the reason why it is accepting jurisdiction. The analysis is, there's three different parts as to the reason why Kansas can accept jurisdiction: emergency, inconvenient forum, or the parties are just simply no longer there. Again, we can't apologize.
Okay, and our record here shows that at volume 12 page in the range of beginning at 313 and continuing, the Judge Segarra took the time to kind of say, okay, this is my explanation of what the conversation was. She outlined the conversation between herself and the California judge. So are you attacking her iteration of what was said between the two of them did not cover the merits kinds of things that needed to be said? Are you attacking that?
Yes.
Or are you just saying that that's not an adequate substitute for the record?
I don't think it's an adequate substitute for the record. There's additional parts of the record where if all of a sudden her analysis is this is what we appeal all the time, is this court's analysis, this is the reason why we disagree with it, this is the reason why we're up here arguing in front of you as to the reason why you should reverse that decision. If we don't have that record, so even though she necessarily says this is what we talked about, well, maybe you also talked about this, or this is the analysis for the inconvenient forum, but we don't have that record to give us the ability to contest that.
So we have situations all the time where a record can't be made. There are failures of the tape recorder, and the tape recording is inaudible. So we have rules set up that allow us to substitute, to make a substitute record in that situation. And it appears that an argument could be made that Judge Segarra's statements on the record here would be the equivalent of what we require when those situations arise. And she said, no, I did not have a recording, I did not have a court reporter, I depended on the California court to do that. So why would those rules not come into play here, and we would accept what she said as our substitute record?
So if the substitute record then contains the analysis, the complete analysis as to, okay, well, Judge Segura was accepting transfer based upon it being an inconvenient forum. Well, then, once we have that record made, and again, I don't believe that any record was made until it was objected to at the termination hearing, then all of a sudden we have to deal with it really at the last part of the case where it seems like all is lost anyways. However, so she substitutes it, we go in and say, well, okay, if you're making an inconvenient forum analysis in order to accept transfer, we should be able to attack that even on appeal, that this was in fact not an inconvenient forum. Obviously, we're not saying that that wasn't appealed, was this being an inconvenient forum. It was appealed that there was an incomplete record to suffice for subject matter jurisdiction to be conferred on Kansas.
So if we determine that that substitute record fills the gap under the circumstances that are presented, then you have no argument? I mean, is your argument totally hinged on the lack of a record of that conversation?
I'm not going to say it's totally hinged on it. I think that the process still has to be observed as to the creation of the record at the time of the conversation or the communication between the courts. I don't think it's inappropriate to have a post hoc order saying, well, this is what we talked about. It should be
Sometimes
made.
that's all that's available. I think that's my colleague's point.
Yeah.
I'm just trying to hone in here. You're making an argument that this was procedurally insufficient because it should have been a contemporaneous record, and that Judge Segura bore responsibility for creating that record at the time, even though she had not yet accepted transfer and there was no case in Kansas. Is that right? That's argument number one.
Yes.
Okay, and that was a procedural flaw. But you're also arguing that what was said in what may be analogous to a kind of a recreation of a record in all kinds of circumstances in Kansas when there's been a record failure, that it's substantively insufficient. Am I understanding you? Or are you making only the procedural argument?
I believe it becomes substantively insufficient, as you've stated, because of the fact we cannot
Because
go.
she didn't recite the three bases and say, I'm choosing this one for a basis for accepting jurisdiction.
Yes,
So you're making both a procedural and substantive argument.
yes.
Thank you.
Let me go back then, because I asked you a question earlier, what was the minimum that Judge Segura had to have done to satisfy you, and your response, as I wrote down, is record this.
And I agree.
So had she recorded the conversation that basically was the same as what's indicated in her recitation later on the record, I understood you to say that was fine. But now it sounds like you're saying there are two different problems.
I think the record has to occur contemporaneously at the time of the record being created. In other words, or at the time of the communication being created.
Got that part?
So her going back after the fact and then saying, well, this is what was communicated, really leaves us bare as to what we can go back and say, well, no, hold on a second. That's not what was in the record. Yes, I understand this is what your order contains, but that's not what the record supports. And we don't have that ability. So without that minimum record contemporaneous to the communication, we can't go back and say that her order is flawed.
Earlier, I'm sorry.
So even if you looked at what she said on the record and said, that may all be true, but it wasn't recorded?
I'm certainly not here to say Judge Segura is a liar. But what I am saying is that she has an obligation to the mother in this case, because this is certainly her parental rights being terminated, to do the procedures that are set forth in the statute, to record, to make sure she has appropriately accepted subject matter jurisdiction of this case. And if that has failed, then really mother is stripped away of that constitutional right.
How do you connect the dot from there to, therefore, the Kansas court has no subject matter jurisdiction?
The lack of a record,
Yeah.
in order for
I understand your claim is, hey, we're out of luck because we can't now challenge the merits of this court's acceptance of subject matter jurisdiction. But I'm having a hard time seeing how you make the leap from, therefore, as a matter of law, there's no subject matter jurisdiction.
In order for Kansas to take jurisdiction of this case, it has to go through proper procedures. If we cut off that proper procedure and we just simply say, yeah, we have jurisdiction, really the policy argument is, as long as the judges talk a little bit and say, yeah, let's take it, then all of a sudden a bunch of other states are just going to start shipping kids to Kansas or cases to Kansas.
So your argument is this, am I right that the statutory provision you're relying on is 37,110?
You are correct.
Your argument then is that the requirement of a record set forth in that statutory subsection is a condition precedent to obtaining subject matter jurisdiction.
Yes.
And where do you get that from the statutory scheme? It doesn't say it in 37,110.
Then why put it in there? I guess is my
That
question.
goes to my remedy question, because there are other kinds of remedies.
Sure. Is if we don't create a record and we don't give the Kansas courts subject matter jurisdiction, then that's the remedy is then every order that was ever given is void. So if the statute sets forth, well, this is how we're going to get subject matter jurisdiction in order for all of our orders to be good orders, then you have to follow these procedures. That means you have to have a recording, you have to have a record of the actual transfer and the communication between the courts. If we don't have that, then we failed at the very front end of it. And guess what? This court is acting without any jurisdiction to make orders in this case. If it's acting without any jurisdiction to make orders, then everything it has done subsequent to that transfer is void.
So, to go full circle to where I started with you, are we just talking about Kansas?
We are
The
just
Kansas
talking
judge?
about Kansas.
So, you are not attacking anything that the California court did. I mean, your brief made it seem like you were, but are you now saying, no, we are just focused on Kansas?
We are just focused on Kansas. I mean, yes, California has an obligation to probably make an appropriate record, at least as to its proceedings. But Kansas, again, the statute is directed at the court to make a record of its communication with the other court to determine why it is in fact accepting. If the Kansas court did not make that appropriate record, then how can Kansas show that it was in fact the appropriate court and had jurisdiction over the matter? So that would be my yes.
And very quickly on your other argument, I just also want to make sure I understand your argument. Is it based entirely on the timing of the termination hearing and that it wasn't within 30 days?
Are you talking about the permanency hearing?
The permanency hearing.
So the permanency hearing, yes. Again, there we have another procedural due process right that has in fact been granted to a party. And the purpose of having that is for the party to be able to show, yes, I know the state wants to proceed with termination. I still have the ability to reintegrate these children into my home. These are the reasons for that purpose. Without having that hearing to show to the court that yes, I can reintegrate these kids, the court has really predestined that no, we're going to terminate because I'm not interested in what the mother has to say regarding reintegration at this point. Let's have a termination hearing. If we're solely on track for termination, then the only thing the state has to do at this point is put on clear and convincing evidence that this mother is unfit and that it's in the best interest of these children to have her rights terminated, without giving her the opportunity to say, we can't even get to that point of termination because you haven't given me an opportunity to show that I am still a viable candidate for reintegration.
Okay, thank you.
Any further questions? What are you asking us to do, counsel?
Your Honor, I'm asking for you to overturn the termination and void all prior court orders and send this case back to California.
Thank you,
Thank you.
counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.